Hi folks, welcome to SQE One Window. We will try to explore today liability for animals and product liability, and I have put law in the background. So to start with understanding liability for animals, we have already looked for careless drivers, noisy neighbors, and dangerous occupiers. Now it's time to talk about animals and products. This chapter or this topic is where old meets new, centuries old common law on animal meets modern consumer protection law and animal laws that we got in this country. So that's what sometimes is tested, but I would say like there were a couple of questions, I must admit. So let's start with animals. The law has always been fascinated by them, especially when they misbehave. The key principle is that the keeper of an animal may be liable when it causes damage. The main source of law here is the Animal Act 1971, which replaced the old common law rules. It divides animals into two categories. Number one, dangerous species. For example, American bullies excel. We were talking about this debate. Those not commonly domesticated in the UK and that are likely to cause severe damage, such as tigers, snakes, and pet crocodiles. And I heard some people they domesticate them and they put them as pets at their homes. And yes, sometimes even the most innocent looking animal cause serious trouble and strict liability follows. I should be careful about my cat. Okay, so dangerous and non-dangerous species. Now under the Animal Act 1971, liability depends on which category the animal falls into. For dangerous species, the law is very simple: strict liability. If your tiger escapes and mules a neighbor, you are liable, full stop. That's it. The court will not care that you kept it well fed and played classical music in its enclosure. But most claims involve non dangerous species, the everyday animal, pets, for example. Section 2, subsection 2 of the Act applies here, and this is where things get interesting. To establish liability, three conditions must be satisfied. The animal had abnormal characteristic at the time. The keeper knew or should have known of those characteristics, and the damage was likely to occur if those characteristics appeared. For example, a normally calm horse that panics and bolts into a car might still trigger liability if such behavior was foreseeable. In Cummings versus Granger, a god dog attacked an intruder. It was a god dog, like a normal one, but it attacked intruder. Liability arose. Why it arose at that point, we need to understand that even though it was trained to guard, not attack indiscriminately. So at that point, if a guard dog attacks, liability may occur. Another Hanley case: a frightened horse escaped into a road and caused an accident. The court said even temporary panic can count as an abnormal characteristic. And you have watched a video, like it was a couple of years or a couple of months ago, like two horses, they escaped on London Road and they injured themselves and people. So yes, you might love your horse, but if it behaves like a rocket or rocket on legs and you know it, you could be liable. So don't let your horse become a rocket. So defenses and remedies, of course, there are defenses. The Animal Act 1971 is strict but not heartless. It got heart in it. People who were enacting it, they have just included some defenses, and those defenses are fault of the claimant. If the claimant provoked or mishandled the animal, never poke an animal. So trespass. If someone unlawfully enters your land and gets bitten, the court is unlikely to sympathize. It's written, beware, dogs are there. Another thing is voluntary non-fit injuria. That's what we talked about. Consent to the risk. So if you willingly pet a growling dog after being warned, don't go near it at that point. You are the one who accepted the danger and consented to it. Statutory authority: if you are acting under legal power, such as pest control or police animals, at that point, of course, it's a defense. Remedies are mostly damages for personal injury or property damage, and in serious cases, criminal liability may also arise under the Dangerous Dogs Act 1991. Never keep American Bully XL at your property. So, in short, keep your animal under control, know their habits, and maybe avoid buying a lion that was on these slides unless you plan to live on an island. I would suggest even don't take it once you are on island, because you will be alone, and lion and tigers are mighty. So another thing is product liability that we need to understand, from fault to strict liability. Say this is the law that protects consumers when things go wrong with manufactured goods. For example, you bought a blender, it went wrong, and the blade injured someone or went out of the blender. It was a blunder, not blender. The key statute in the Consumer Protection Act the key statute here is Consumer Protection Act 1987, which introduced strict liability of defective products. So under Section 2, subsection 1, producer, which can include manufacturer, importer, or even retailer who sells under their own brand. It happens most of the time. People get it produced from China and they put their stickers on it, is liable for damage caused by a defective product without the need to prove negligence. It's a strict liability. So Section 3 gives us the test. A product is defective if it does not provide the safety that the public is entitled to expect, considering all circumstances of using that product. So we look at how the product was marketed, what warning came with it, and how it was likely to be used. So I have a heater here. This is electric heater. So everything is there. They have put warning, do not cover, do not touch the surface. Like, so all warnings are there on the heater. In A versus National Blood Authority, patients were infected with hepatitis from blood transfusion. The court held the blood is defective because it carried a risk the public did not expect, even though testing technology was limited at the time. That case showed that the law prioritizes consumer safety, not manufacturing convenience, that it was not convenient to put stickers on the heater and all. Defect can come from three main sources: design defect, a flawed concept like a phone that overheats and rusts; manufacturing defect, one faulty batch. For example, I have given you blender's example, and the blade went out. Failure to warn when consumers are not told of known risks that are involved. So even if a product works as designed but is dangerous due to poor warning, liability can arise. That should be careful if you are going to start a business or startup at that point. So let's go to our favorite SQE1 focus slide, and I'll try to understand what we need to keep in mind once we are sitting in SQE exam and there is question about animal or product liability. So let's put this together. When you see a question involving an animal, start with Animal Act 1971. Ask what kind of animal it is, dangerous or non-dangerous. So bar will be very high with the dangerous animals. Did the keeper know of an abnormal characteristic where their, for example, where their defense is like constant trespass or claimant's fault? So we need to understand, was there any consent by the defendant, or trespass it was, or claimant's fault it was. But for product liability, move to Consumer Protection Act 1987 and ask, Is the defendant a producer, importer, or own brand seller? Was the product defective under Section 3? Did the defect cause injury or property damage? Are there defenses such as compliance with the regulation they have done everything they were supposed to do, misuse by consumer, or development risk? And remember, the focus in both areas is on control and responsibility. The keeper controls the animal, the producer controls the product. When control meets risk, the law imposes accountability. Your golden SQE question: has the defendant created or allowed any unreasonable risk through their animal or product? If you can answer that clearly, you have nailed the analysis and understanding. So this chapter, to give you a summary, shows two phases of strict liability. One is ancient, the farmer whose bull breaks through the fence. The other is modern, the company whose toaster catches fire. So both remind us that the law expects care from those who control dangerous things, whether living or man-made. I hope it makes sense, and in order to expand your understanding, enhance your understanding, I would suggest download our notes and go through our question sets, and those will be available shortly. Thank you.